Courts try cases, but cases also try courts. Justice Robert Jackson. This video is all about the landmark case of Prosecutor versus Tadic. In a nutshell, this is all about war crimes at a Serb-run concentration camp in Bosnia-Herzegovina, and eventually the contribution of the case to international law. But before we present the case, let's have a short background of war crimes in other conventions pertaining to this case. So what is a war crime? Under Article 8 of the Rome Statute of the International Criminal Court, war crime means grave breaches of Geneva Conventions of 12 August 1949. Namely, any of the following acts against person or property protected under the provisions of the relevant Geneva Conventions, among others, are willful killing, torture or inhuman treatment, including biological experiments, willfully causing great suffering or serious injury to body or health, extensive destruction and appropriation of property not justified by military necessity and carried out unlawful and wantonly, compelling a prisoner of war or other protected person to serve in the forces of a hostile power, willfully depriving a prisoner of war or other protected person of the rights of fair and regular trial, unlawful deportation or transfer or unlawful confinement, and lastly, taking hostages. Now, let me introduce you to the International Criminal Tribunal for the former Yugoslavia, or simply ICTY. ICTY was a United Nations court of law that dealt with war crimes that took place during the conflicts in the Balkans in the 1990s. It provided victims an opportunity to voice the horrors to witness and experience, and prove that those suspected of bearing the greatest responsibility for atrocities committed during armed conflicts can be called to account. Now, who is Tadic? Duško Tadić is a Bosnian Serb politician. Former SDS president of the local board of the Serb Democratic Party in the town of Kuzarak, Prijedor municipality. Also a former member of paramilitary forces supporting the attack on the district of Prijedor. On May 24, 1992, Bosnian Serb forces attacked the town of Kuzarak and began an artillery barrage. Mostly Bosniaks or Muslims were targeted that resulted in the killing of 102 children, 256 women, 31,000 men and boys held in camps, and 53,000 forced to flee as refugees. During the occupation, Tadic participated in the collection and forced transfer of civilians. Duško Tadić was the first person tried by the ICTY and the first to appear before an international war crimes tribunal since Nuremberg. Accordingly, he was charged with crimes against humanity, namely persecution on political, racial, and/or religious grounds, murder, and inhuman acts, grave breaches, and the 1949 Geneva Conventions, namely inhuman treatment, willful killing, torture or inhuman treatment, willfully causing great suffering or serious injury to body or health, and violations of the laws or customs of war, namely cruel treatment and murder. The accused was arrested on 12 February 1994 in Munich, Germany. He pleaded not guilty to all counts during his initial appearance at the tribunal and later on the trial chamber too. However, on 7 May 1997, the trial chamber found the accused guilty on 9 counts and guilty in part on 2 counts. of crimes against humanity, namely persecution on political, racial, and/or religious grounds, and inhuman acts, the violations of the laws or customs of war, namely cruel treatment. On 14 July 1997, the trial chamber imposed concurrent sentences of imprisonment, the highest being 20 years. Both the accused and the prosecution appealed the trial chamber's judgment to appeal chamber. Particularly, the accused appealed the sentencing judgment. The issues raised by the accused were as follows, and how did the appeal chambers rule? Did the appeals chamber have the jurisdiction to entertain these claims as an interlocutory appeal? But before answering the first question, let's answer first the questions of whether or not the International Tribunal is legally founded. Yes, International Tribunal is legally founded as it was established by law. The entitlement of an individual to have a criminal charge against him determined by a tribunal which has been established by law is provided in Article 14, Paragraph 1 of the International Covenant on Civil and Political Rights. Similar provision can be found in Article 6, Paragraph 1 of the Europe Convention on Human Rights and in Article 8, Paragraph 1 of the American Convention of Human Rights. It is clear that the legislative, executive, and judicial division of powers, which is largely followed in most municipal systems, does not apply to the international setting, nor more specifically to the sitting of international organizations such as the United Nations. Among the principal organs of the United Nations, the division between judicial, executive, and legislative functions are not clear-cut. Regarding the judicial functions, the International Court of Justice is clearly the principal judicial organ. That is to say, there exists no corporate organ formally empowered to enact laws directly binding on international legal subjects. What is important is that it be set up by a competent organ in keeping with the relevant legal procedures, and that it observes the requirements of procedural fairness. Now, since we already established that International Tribunal is legal, now let's answer the issues on jurisdiction. The appeals chamber rejected a narrow interpretation of the concept of jurisdiction that would fall foul of modern vision of the administration of justice. In other words, if we will construe strictly the rule on jurisdiction, justice would not be served. It further argues that a narrow concept of jurisdiction may, perhaps, be warranted in a national context but not in an international law, and that the challenge to the validity of the tribunal's establishment went to the very essence of jurisdiction as a power to exercise the judicial function within the ambit. Accordingly, the chamber stressed that the tribunal was not an ordinary subsidiary organ of the Security Council. It derives its creation from the latter, but a special kind of subsidiary organ that has a power to determine its own jurisdiction. The appellate chamber has also added that the main functions of the Security Council is to determine the existence of any threat to the peace, breach of the peace, or act of aggression, and shall make recommendations or decide what measures shall be taken in accordance with Article 41 and 42 to maintain or restore international peace and security. An armed conflict or a series of armed conflicts has been taking place in the territory of the former Yugoslavia since long before the decision of the Security Council to establish this international tribunal. If it is considered an international armed conflict, there is no doubt that it falls within the literal sense of the words breach of peace. But even if it were considered merely as an internal armed conflict, it would still constitute a threat to the peace. Hence, it is clear that the Security Council has jurisdiction over cases that are threat to peace, and so the tribunal that is created by the Council has also jurisdiction to try the case and or to appeal chamber to entertain interlocutory appeal. Whether or not tribunal lawfully exercise primacy over domestic courts. Indeed, when an international tribunal such as the present one is created, it must be endowed with primacy over national courts. Otherwise, human nature being what it is, there would be a perennial danger of international crimes being characterized as ordinary crimes or proceedings being designed to shield the accused, or cases not being diligently persecuted. It would not be travesty of law and a betrayal of the universal need for justice should the concept of state sovereignty be allowed to be raised successfully against human rights. Borders should not be considered as a shield against the reach of the law and as a protection of those who trample underfoot the most elementary rights of humanity. Whether or not the subject matter of armed conflict is a matter of international or a municipal concern. International humanitarian law governs the conduct of both internal and international armed conflicts. The definition of armed conflicts varies depending on whether the hostilities are international or internal both. Contrary to appellant's contention, the temporal and geographical scope of both internal and international armed conflicts extend beyond the exact time and place of hostilities. With respect to the temporal frame of reference of international armed conflicts, each of the four Geneva Conventions contains language intimating that their application may be extended beyond the cessation of fighting. Accordingly, an armed conflict exists whether there is a resort to armed force between states or protracted armed violence between the governmental authorities and organized armed groups or between such groups within a state. International humanitarian law applies that from the initiation of such armed conflicts and extends beyond the cessation of hostilities until a general conclusion of peace is reached, or in the case of internal conflicts, a peaceful settlement is achieved. Until that moment, international humanitarian law continues to apply in the whole territory of the warring states, or in the case of internal conflicts, the whole territory under the control of a party, whether or not actual combat takes place there. Applying the same in the case of Tadic, even if substantial clashes were not occurring in the Prosecutor region at that time and place the crimes allegedly were committed, international humanitarian law applies. It is sufficient that the alleged crime were closely related to hostilities occurring in other parts of territories controlled by the parties to the conflict. There is no doubt that the allegation at issue harbor the required relationship. In summary, on the basis of the foregoing, we conclude that the conflicts in the former Yugoslavia have both internal and international aspects, that the members of the Security Council clearly had both aspects of the conflicts in mind when they adopted the statute of the International Tribunal, and that they intend to empower the International Tribunal to adjudicate violations of humanitarian law that occurred in their either context. To the extent possible under existing international law, the statute should therefore be construed to give effect to that purpose. Let us now go to the contribution of this case to international law, particularly for the international humanitarian law and international criminal law. Contribution to international humanitarian law. The decision in Tadić case is carefully reasoned and innovative judgment, which is likely to have a profound effect upon the development of international humanitarian law, particularly in the field of internal armed conflicts, where it has international humanitarian law and Tadić case developed both the substantive law and the concept of criminality. The Tadić definition of armed conflict for the purposes of the applicability of IHL, which establishes different tests of international and non-international armed conflict, has had a lasting impact. Also, it added, hey, the classification of international armed conflict shall now become an international concern, is limiting its subject matter jurisdiction to crimes committed only in an international armed conflict would defeat the underlying purpose of tribunal, since many of the alleged offenses had taken place in situations of internal armed conflict. Hence, that the grave breaches regime was applicable to all types of armed conflict under Article 2 of ICTY. Further, Article 5 of crimes against humanity, Article 3 or violations of laws or customs of war shall now be applicable to international or internal armed conflicts. So, contributions to international criminal law. The appeals chamber again broke new ground by holding the customary international law imposes criminal liability of serious violation of common Article 3, as supplemented by the other general principles and rules on the protection of victims of international armed conflict, and for the breaching certain fundamental principles and rules regarding means and methods of combat in civil strife. Accordingly, there was no precedent for this pronouncement. Conventional law regulating internal armed conflict, Common Article 3 of Geneva Convention and Additional Protocol 2 did not require prosecution or establish universal in a manner to the regime for grave breaches in an international armed conflict. Indeed, it did not even refer to criminal liability. To wrap up the contribution of the Tadić case for lawmaking and legal reasoning in an international law, let's borrow the words of Judge Antonio Cassisi when asked, what was the most important case that you sat on? Probably Tadić, because I pushed so much and exploited the Tadić case to draw as much as possible from a minor defendant to launch new ideas and be creative. Actually, Tadić offered us the opportunity to pronounce on the legality of the tribunal, whether the tribunal had been set up in conformity with the law. The question on whether it would be appropriate to make a distinction between war crimes committed in internal or civil war and international conflict, and also the question of the extent to which a civil war may turn into an international war. Yes, courts try cases, but this case, the Tadić case, it tried the courts, the international courts. Thank you for listening and have a good day. Goodbye.